What should I avoid saying to CPS in California? Well, it's kind of hard to say what you should or shouldn't avoid to say, and especially when you're being investigated and there is a referral for investigation for child abuse or neglect or maybe sexual abuse. It's always best to contact the California CPS defense lawyer to see what's appropriate, to see what you should and shouldn't say. Even though you have the right to remain silent, and even though you have the right of counsel to be present during any type of investigation by any government entity, there are some times that providing information can be helpful. But if the allegations are very extreme, it's usually best to not say anything at all and to exercise your right to remain silent. Oftentimes, CPS will make threats because they want to get information. Remember, they're just doing their job. They want to get information of what took place because they have no other source to determine what took place besides your words. Sometimes they will manipulate you and they will say things such as, if you don't cooperate, the word cooperate, implicating that if you don't do what I say, things can happen. But sometimes they'll go to the extreme and say, if you don't cooperate, we will take your kids away or your kids will not return in your care. Now let me tell you this, whether you cooperate or not, if they have enough evidence and they have a basis, they can remove your child. Providing information to them can typically only hurt your case or give them more information to make a decision. But again, remember, it could be helpful or not helpful. It just depends on the facts and circumstances of your case. But remember, you have the legal right to do so. For more information, make sure you contact us at Shaw 3 Law Firm so we could advise you, we could talk to you, and tell you what the best plan of attack is.